And I want to formally and officially welcome everyone to our INBLF Great Legal Minds lecture series. And today, of course, we are conducting a webinar focused on litigation in the brave new world, the world of virtual litigation. My name is Nancie Marzulla. I am president of the Washington, D.C. chapter. And Harry Payton, who is president of the Florida chapter, and I put this program together, and it is designed to showcase some of the vast numbers of talented attorneys we have with expertise on these and other issues. So our goal today is to showcase in an overview fashion some of this talent and to focus on these issues. And at each panel, the thought is we may have time for a few questions. If not, we do plan a open floor forum at the end of the plan program. And then we also encourage everyone to reach out to any practitioner if you want to follow up on an issue in depth. So I think everyone knows that the program is being recorded. It will be posted on the INBLF website. And I think that's basically it. I now want to turn the program over to our first panel, which will be chaired by Harry. That first program panel is Taking and Defending Virtual Depositions.
Thank you, Nancie, and welcome everybody. I'd like to thank Nancie for the tremendous job she's done in putting this program together. Nancie, as you know, is one of the country's top environmental lawyers who spends a great deal of her time in the Court of Federal Claims. Also on the panel is Chelsea Nunez, who is Veritext account manager and my account manager. She's done a tremendous job for me over the years that she's been with Veritext, and I have used their virtual tool product successfully in the past. The subject that we're going to address is taking and defending virtual depositions. There are three rules in connection with taking depositions or defending depositions virtually. The first rule is preparation. Preparation is the second rule, and I guess you can figure out what the third rule is. Also, preparation. Preparing in advance and letting your witness know who's going to be on the other side, where the court reporter is going to be, what you're going to be doing with your exhibits, which brings up the issue of exhibits. You have several choices with respect to exhibits, which I think pose one of the larger problems in connection with virtual depositions. You can share screens. That doesn't give the opposing counsel an opportunity really to deal with a hard copy, put it aside while he's waiting for the deposition to conclude and ask questions on cross-examination. You can, depending upon the circumstances, provide counsel and the witness with the exhibits in advance. That's really being prepared. Or the third way you can deal with it is by emailing to opposing counsel and to the witness as you're about to use them, the exhibits. Of course, you have to figure in the court reporter there. The court reporter has to have the exhibits to mark. I find that when you introduce the witness to the scenario, that is, we're going to do this virtually, you and I will be at remote places, the court reporter and the opposing counsel are going to be at remote places. We're going to have an opportunity during breaks to have a telephone conversation if we need to, etc. That causes or helps the witness prepare for, at least mentally prepare for the deposition. want to address the issue of court reporters. I always instruct the court reporter when I start a deposition that I'm very record conscious. I don't want phonetics in my transcript. And I don't mind if the court reporter stops me at the end of a sentence or stops opposing counsel at the end of a sentence and says, I'm sorry, but I didn't get that for one reason or another, whether, and we deal here in Florida with people with heavy accents, which makes it doubly difficult to conduct a deposition, or for whatever reason, talking over one another, for example, is a good reason why the court reporter doesn't take all of the statements down. So I think if you do that and you wait for the examiner, if you're not conducting the examination, to finish the question before you interject with an objection of one sort or another, I think that works very well. And maybe you have an understanding with opposing counsel. You're going to wait till each of you finishes a sentence before you interject. There are some hints about the depositions. I found, and I started when I was a young attorney on somebody else's advice, that it's always good to read a deposition and digest a deposition just as soon as it's transcribed. The reason for that is you have occasion to use that testimony throughout the balance of the proceedings. I know that there's some attorneys wait until summary judgment motion before they start reading depositions, but I think that's a little bit late. You can use the information in the digest as a guide to examining other witnesses in the case. I'd like to tell you about a technique to use with a witness who is too talkative. I think that's the bane of my existence. Is there a question?
Okay. It's okay. It happens, okay? It'll be okay.
Hello?
Make sure everybody's screen is on mute, please.
What do you do with a witness who's too talkative? We all try and understand them, so we're all minor psychologists in a way. You know, it could be ego. It could be they want to get out of the deposition. They think they'll get out of the deposition faster. They want to explain their case fully, so they're going to overwhelm the other side. They do it out of discomfort, whatever it is. I was confronted with a witness like that some time ago. We had been litigating over the construction of an office building, and we were about to settle the case when the other side subpoenaed a real estate broker who was an ally. This gentleman was a 21-year-old real estate broker who went on to become very successful in New York, but he had an incredible facility. He could walk into a room of people, and in 5 minutes, he could alienate everybody. I've never seen anything like it. But a good guy. So I was beside myself because I figured that if he testifies and opens his mouth and goes on and on and on like he's prone to do, that our settlement is going to get torpedoed. So I wound up speaking with a communications professor at the University of Miami. And she taught him and me a technique that I have used very successfully since that time, which was now some time ago. It's called wrapping the answer around the question. You know, we usually instruct witnesses to yes or no, or I don't know, keep it as brief as possible. Notwithstanding that, they go off on tangents and they provide fodder for the next question. And I think all trial attorneys could keep a witness under oath for 8 hours just listening to their answer, and you get the next question. What this process does is it causes the witness to process the question and to respond using the question in the answer. Now, for example, if I ask you, and each of you looking at me right now, do you know what time it is? And you're under oath. What do you think the right answer is? Nobody has looked at their watch so far as I can see. So the answer would be, I do not know what time it is, unless there's a clock on the wall over my shoulder that I wasn't aware of. Usually a witness will pick up his shirt sleeve, look at his watch and say, oh, it's 1:45. That's not the right answer. Give you examples, simple examples. Question, what is your name? My name is Harry Payton. I practice law in Miami. Where were you on the night of August 5th? On the night of August 5th, I was at. Is it your objective that you're going to teach some people something that is not very well known? It is my objective to teach people something that is not very well known. I have found that after training people to do this, they forget about it 5 minutes into the deposition, at least as to something like 60 or 70%. But those who use it very, very successfully. I've had parties use it on the witness stand. I've had a judge say, Mr. Payton, after 2 hours, the witness doesn't have to repeat the question. And my response is, Your Honor, as long as the witness is telling the truth and gives a responsive answer to the question, that's all that the court can require. And so it goes. So I invite any questions over what we've covered before I pass the podium to Nancie. Nancie?
Sure. Thank you, Harry. I started taking virtual depositions long before COVID-19, and that's because I practice in the Court of Federal Claims, which, as many of you may know, is a national court based in Washington, D.C., and our court hears all of the claims for monetary damages brought against the federal government that are not tort-based. So these would be federal contract claims, federal takings claims, federal back pay cases, tribal trust cases, and the like. And the point of this is the fact that the court itself is cognizant of the fact that it is a national court. And about a decade ago, this court pioneered the effort to bring technology to bear to conduct depositions and hearings and status conferences so that the court could in fact serve the nation of counsel and witnesses, or excuse me, parties before the court. And so long ago, we started with our law firm embracing technology to take depositions and to put on witnesses in court with live technology, using the court's technology. And frankly, in the early years, it was pretty spotty, but it has increasingly gotten much more sophisticated, again, because the court has fully embraced technology for this purpose. And then under COVID-19, it is even more so. And it's brought in Skype to add to its arsenal of tools available to counsel. And I have found that the use of technology has really made our boutique law firm very competitive. And so, for example, all of our defendant in all of our cases is the Department of Justice. And they, of course, have an army of attorneys to deploy in depositions. They can send them anywhere in the United States. Well, about 5-8 years ago, we had 40 depositions that DOJ had either set or insisted be taken from coast to coast. And they all had to be taken within 1 month. So we're, of course, the plaintiff, and we've got our client pushing us to get this case resolved. So we had the choice of going to the court and throwing ourselves in the court's mercy and begging for more time, or alternatively figuring out a way to take all and defend all these depositions. We chose the latter, and we used technology to do this. We did telephonic depositions primarily. We did some video depositions, and then only those depositions that were just crucial that we be there in person did we in fact fly to the location where the deposition was taken. So that sort of leads me to my first point that I want to leave you with you here today, which is one of my 3 tips. Like Harry, I have 3 tips for you on how to make use of virtual technology, how to use technology to your advantage in your cases. And that first tip is to realize that not all depositions are equal. So you may have a fact witness, and all you want from that fact witness, all you need to get from that witness is one issue. You need him to testify about one issue that is pretty straightforward, and it's not going to be much of a problem to get. It's not an adversarial witness. You just need to get it on the record. You need that evidence to introduce a trial. So that is very much a deposition I would strongly consider taking telephonically. At the other end of the spectrum, of course, is the expert witness that has to address complex issues. He's experienced, he or she is experienced, adversarial, and you've got a strong opposing counsel. That is a witness that I would either want to be there in person if I could, or alternatively, I would want to be there videotaping. So that's kind of your spectrum, and knowing that there are costs associated as well, costs in terms of time and client resources for your deposition. So regardless of COVID, I think it's always important to ask yourself, where do we put our resources? How do we utilize our resources so that we can prepare and win our case? The second point I want to make is that make sure your technology is up to the task. Now, this may seem like an obvious point, and of course, we're all experienced litigators, and who in her right mind would not check her technology before starting a deposition? Well, of course, I have a horror story. We had just launched our new wireless system. I am eager to try it out. I've got a deposition set telephonically. Fortunately, it's not a crucial deposition. Nevertheless, it is a deposition, and I need to get something from it. So I launch off with my new voice over internet technology, and of course, it starts cutting out. So I have to go. I mean, the deposition should have taken 45 minutes. I think it took 2.5 hours because I had to take breaks and come back and get help and go back. And so don't do that. Test it out ahead of time. Make sure it works. And this is where working with a trusted partner, a virtual technology. Chelsea, this is for you. I'm queuing you up here. Work with a company that you know you have a relationship with and that has a national presence or a track record, so that you're not going to be let down. You're not going to be caught flat-footed, and you know your technology is going to be there for you. So all you can do, or all you have to do, is focus on getting from your deposition what you need to get. And then finally, my third point is to echo what Harry said, which is prepare prepare. In a virtual deposition, you have to know your exhibits ahead of time. Now, I still always insist on handing out my depositions one at a time. I don't like to hand over a notebook at the head of the deposition because I feel like that ties my hands. But I do have them set out ahead of time. I give them to the court reporter who will be there with the witness. And then I can tell the court reporter, let's go to exhibit number 6 or whatever the exhibit is that I'm going to go to. You can't be fumbling around. You can't be staring at the document, wondering what you're going to ask, as if you've seen it for the first time. You can't be going back and forth. I mean, it is possible to backtrack if it's crucial, but by and large, you want to go a seriatim. You take your first exhibit, go to the second, go to the third, and work through your mapped out, pre-planned deposition. I think that is, I have found that to be the most effective and the best way to make sure that your deposition goes smoothly. So with that, I'll close my remarks, but just to sum up, I heartily endorse the use of technology and virtual deposition, and I urge everyone to go boldly into the world of virtual depositions. Chelsea, you're up.
All right. Well, thank you, everyone. I appreciate the opportunity to be able to speak to you. Thank you to Harry and to Nancie for setting this up. For those of you that are not familiar with Veritext, we are the largest HIPAA-compliant court reporting agency in the U.S., and I'm very proud to call Harry Payton a very loyal client of ours. Today, I'm also delighted to share with you a little bit about the remote deposition process, as Nancie and Harry have been talking about, but kind of going through some points, lots of points to consider as you are preparing, as Harry was definitely focusing on. So bear with me just a second, and I'm going to switch over. So hopefully everyone can see my PowerPoint. Again, my name is Chelsea, and I'm representing Veritext Legal Solutions. So some things that you want to consider when you are thinking about doing a remote deposition. Ideally, we would all be doing these in person, but due to the health crisis, that's not possible. Again, the first thing is prepare. So I am quoting Nancie as well as Carrie. You definitely want to prepare. There are so many different factors in terms of what technologies you're going to be using and who all has the credentials, who all has the links, the passwords, etc. You also want to test, again, chiming in from Nancie, you want to test the technology. And that doesn't mean only, a week in advance when your deposition was set, but you want to get there the next day or the day of the deposition and connect early because you're still dependent on the internet and technology and there are glitches. So you want to have that extra time built in to be able to troubleshoot. Additionally, you want to discuss with the counsel how you're going to be capturing the record. Are you using only a court reporter, or are you going to be using a videographer in conjunction? Prepare and test, as we were talking about, connecting early the day of the deposition. Don't just log on 5 minutes before the deposition because it is still the internet that you're working with and glitches can occur. Capturing the record, are you going to have a stenographer? Are you going to have a videographer? How are you going to handle the exhibits and videography? So additionally, some other things that you may want to discuss are in terms of the stipulations. You want to make sure that everyone knows that this is a remote deposition. That sounds silly, but there are people that will show up and not realize that it's a remote deposition, that you're doing it via the internet, that you're using the web. You may want to discuss breakout rooms ahead of time as well, so that if anyone wants to have an individual private conversation, they can do that. Again, exhibits, that's a very big key, and technical issues. Since you are working from home, you can't just call up your IT or have them run down the hall. You need to have a plan B as to how you're going to deal with your technical issues. That will come up, unfortunately, as much as you prepare, things just happen. Now, with Veritext, I can tell you that you are going to have all the participants receive their credentials. You are going to have your connectivity tested as well. Exhibits, we will discuss how you're going to be managing exhibits, and our professionals are going to be on the line 30 minutes in advance. Again, just trying to troubleshoot and make sure everything goes well. And each of the participants that are going to take, are going to participate in our depositions that we're scheduling are going to get our practice guide. So I will address that a little later in the presentation as well. Just gives you some step-by-step instructions. So in terms of the components of a remote deposition, you have the video, and the video is done through your webcam. You also have the audio. A lot of people are using computer audio, but we really suggest, especially since everyone is remote and the court reporter is the one taking down the record, that you call into the number that is available to you. There's two reasons for that. One, the audio is crisper, and two, heaven forbid the internet goes down, you still have a form of communication to be able to inform everyone that you're having some technical issues. Otherwise, you're just kicked out directly. Again, exhibits. We keep coming back to exhibits. You can integrate real time in a remote deposition. So just because you're remote does not mean that you lose that ability, and videographer as well. Now, when it comes to the actual requirements for a video deposition, if you're on this webinar, you've got everything you need. So computer, a phone, and a webcam. There's nothing that you need to download. There's no licenses that you need to purchase. And you'll notice down below that it says recommended 1.5 megabits. Veritext has actually created their own enterprise version of the Zoom platform because we have recognized that that's the most compatible across the market in terms of equipment and software programs that are being used. It's also the one that uses the least amount of bandwidth. So this 1.5 megabits is very easy to attain in your own home setting versus a corporate environment. And if you're wondering if you have the significant test, you can do that very easily. You can go to speedtest.net, or you can just Google speed test, and it'll show you, for example, what your speed test is. So my machine is 16.2, so I'm definitely good to go.
Well,
now the next thing,
sorry, I thought, go ahead.
Oh, okay. I've talked about videographer. I want to let you know, with Veritext, if you're going to have a videographer, you are going to have one of our professional videographers attend, however, remotely. So this is a home setup of a remote setting for a videographer. They're going to capture the record with a high-definition camera, and they're also going to date and timestamp. So if you're curious as to how that would look, this is a video of the witness who is speaking, and my colleague here is going to point to the time and date stamp right there. And you are also, as a final deliverable, if you decide to purchase the video, is going to receive a video that is time and date stamped. So it'll be trial ready. If you need to sync it to a transcript, it'll be ready. If you need to create video clips, it'll be ready. So it's the same as if it was an in-person deposition. Finally, to the exhibits. So as people have mentioned multiple times, you can send them in advance. Now, this does show a package, but because people are still working at home, a lot of people are emailing them. But as Nancy mentioned, it depends on your strategy. You may not want everyone to see your documents ahead of time. So the other option is during the deposition that you can send them one at a time. You just want to make sure that the reporter has them at the end of the deposition. And then again, you also can use an exhibit-specific tool. Now, I am going to share our own proprietary tool, but I do want to let you know, and I think Carrie mentioned it, that Zoom does have a share screen feature, which I'm using and multiple people have used to show their documents today. This is a tool that you can use if you have only a handful of documents and single pages, because what you're actually doing is just sharing the image of the document, not the full document to the counsel that are participating in the deposition. So let me show you what we would do. We actually have created a secondary tool called Exhibit Share. This is a web-based platform, so you don't need to purchase any license, and it would be secondary to the Zoom product. Once you decide you're going to use this tool for your deposition, it would set you up with an account, and you would prepare for your deposition just as you would normally. However, when it comes to gathering all your documents, instead of printing them and making copies for the deposition, you would just upload them into this file over here that says private. The process of uploading is very simple. You literally just upload all your documents. You can do it one at a time, or you can drag and drop multiple documents, depending on what you're comfortable with, so that you don't have to recreate the wheel, because we know these are ongoing cases that probably have lots of documents. Now, the other party as well is also going to have an account to the exhibit share tool. The difference is they are only going to have the marked exhibits folder, and as you notice right now, this is empty. And that is because this is where the introduced documents will be found. So it'll be the public folder for everyone to access the introduced documents, including the court reporter. So how do you introduce the documents? You can actually, once you have already uploaded this, and this was done on the front end, you're at the deposition, you choose the document that you want, and you click to introduce the document. When you get the document, this is the taking attorney's position, right, that I'm showing you, you're able to preview this document, okay? You're able to also put an exhibit number on there, which you can change if you want, or it'll just go in auto sequence order. Once you choose to introduce that document, you are now delivering that document to all parties, so they have their own local copy on their device. And as you notice, there's also a virtual stamp included as well. So there's a lot more that I can go into detail. I just have a limited window, so I just wanted to give you a brief overview. This is the practice guide that I made reference to. This is where you'll be able to find a preparation checklist, a step-by-step tutorials, as well as suggested notice language, just different practical advice for a fully remote deposition. And finally, if I can be of any service for you, here is my contact information. Feel free to reach out to me or go through Carrie. We'd be delighted to work with you. I appreciate the time you've given me, and I hope everyone has a wonderful afternoon. Thank you very much.
Thank you, Chelsea. So, Roger, do you want to take over panel number 2?
Yes, good afternoon, everybody. Morning to those of you on the West Coast. I'm Roger Marzulla, the other half of Marzulla Law, the lesser half, of course. And our panel today takes us to the next stage of litigation, and that is the hearing and trial process. We have an excellent panel here today that's going to give you different perspectives on how to prepare for hearings, how to present trial testimony, and hopefully to lead us into this brave new world of trial and related litigation processes. First, you're going to hear from Amber Kornreich, who is our Miami family law specialist at INBLF. I will then next talk about our experience in the federal courts, and finally, for follow-up and with, I think, a rather different perspective, you'll hear from Sam Rabin. You know, the courts have generally been closed to business like everybody else across this country, but that doesn't mean that litigation, civil and criminal, has come to a halt. It may have been slowed, it may have taken a detour, but it remains moving forward. And as we start to open up, we're going to see even more changes in the way we present cases, both in hearings and motions and at trial. So what I'd like to do is start with Amber to give us a sense of how it's working in Miami, in the family courts of your state.
Good afternoon, everyone. My name is Amber Kornreich. I practice marital and family law in Miami, Florida at Kornreich Associates. I practice with my father, Jerry Kornreich, who's on today's webinar. It's truly an honor to be on this panel alongside Roger Marzulla, who is truly a legend, and Sam Rabin, who is known to be one of the finest and most professional criminal defense lawyers in Miami. I'll be sharing my screen. Today we'll be discussing 6 tips on how to survive and how to be effective in a virtual courtroom. The first tip is review administrative orders, memoranda, or other notices in your district. Before you proceed to any hearing, it's very important that you make sure that you're up to date about what your judge is going to be expecting from you in terms of how to submit your evidence ahead of time and how to present that evidence. You should consider reviewing the judge's divisional website to see if your judge has specific rules, and you should consider attending CLEs hosted by your local bar associations to see if you can pick up any tips that are local to your jurisdiction. Number 2, prepare your client. It's very important that you ensure that your client can use the technology. By now, we're all pretty familiar with Zoom, but that doesn't mean that our clients are. So we recommend that our clients log into Zoom, check it out, make sure that they get a sense of what they look like on camera. And it's very important that they know how to use the mute function. Just to tell a little story, similar to Nancy, we recently had a pretty nightmarish experience in a deposition. Our client had her screen was off, but she didn't realize that her microphone was not muted. So when the opposing attorney began asking several questions to the deponent on an area of significant exposure, she began cursing and screaming into the camera, not realizing that everyone could hear her. And to make matters worse, she had another person involved in the case who really shouldn't have been with her, who was also yelling and cursing. So this is a cautionary tale. You don't want it to happen to you. Thankfully, we were able to settle that case on a positive note, but it really was a nightmare situation. Another issue is to advise clients to be non-reactive with their facial expressions. When you're doing proceedings on Zoom, the judge has a very clear picture of each person in the proceeding. In family court, we're doing bench trials, so the judge is really looking at each individual square closely. Just yesterday, we had a matter before court, and it just so happened to be that the wife in this case was a former Miss Universe, beauty queen. So needless to say, we were all really looking forward to seeing her, seeing how beautiful she was, seeing, how she was going to show up to court. And instead, she showed up in a pink fuzzy sweatshirt. She looked like she just rolled out of bed. She was laying on a couch, drinking a cup of coffee, didn't have her hair done, was grimacing, smiling, laughing, and this really put a negative effect, lucky for us, but it really put a bad taste in the judge's mouth. So that's a good thing to prepare your clients for. Number 3, test your technology and consider bandwidth usage. This point has already been touched on, but it really can't be overemphasized. You really should do a test run. And if you've never shared your screen before, you should have a trusted person in your office or a colleague work with you to make sure that you know how to control the screen. You should additionally plan for battery failure. Unfortunately, with all of our devices, with all of our charging and all of our best intentions, we just can't, at the moment you need it, your device is sure to fail. So if you're using an iPad or any sort of mobile device, you may consider buying a portable battery charger to have handy. Additionally, at our firm, what we found has been effective is actually using 3 screens. It sounds like a lot, but this is how it works. You have your computer to host the actual hearing. You use either a tablet or a second screen to be reviewing your notes or any other exhibit that you might be planning to use but are not yet ready to share the screen for. And then you have your cell phone close by. So that way your co-counsel can send you a message, or your client can send you a message if there's something important that you need to know in the middle of the hearing. You do not want to be using the chat function in Zoom because sometimes other people may be able to see it and you wouldn't want attorney-client privilege to be compromised. Lastly, you should upgrade your home internet speed if you're working from home, or ask coworkers to take a break from their devices during your hearings. We've heard from other colleagues and judges that when there are multiple people in the house, whether it's children being homeschooled, your spouse watching Netflix, whatever the case may be, the more devices that are going at the same time, the slower your internet speed is. The last thing you want in the middle of your hearing is for there to be a lag. So you may want to either upgrade your speed or ask people to take a break from their devices. Number 4, remember professionalism applies virtually too. Just because we're in this virtual environment doesn't mean that we shouldn't still confer with our opposing counsel prior to a hearing. So if there's any evidence that can be stipulated to, we know already that introducing evidence on Zoom can be very difficult and can take a lot of time. So your judge will appreciate it, your opposing counsel will appreciate it, and it's always a good practice. Number 5, use the buddy system. So what's worked in our firm is to have one attorney arguing or asking the questions and another attorney, or it could be a paralegal, actually putting up the exhibits or handling the documents. It's very difficult, even if you're very tech savvy, to keep your mind on both controlling the screen, looking at the judge, controlling the witness. So the buddy system really works. It's also a very helpful backup plan if your technology fails. If for any reason you all of a sudden are being forced out of the hearing because your technology has failed, your buddy can maybe buy a few minutes with the court while you figure out how to log back in. Number 6, finally, ask for a break. Virtual hearings will necessarily take longer than in-person hearings. Just because you're in a virtual setting does not mean that you cannot ask for a break if you need to go to the bathroom, if you need to confer with your client, or for any reason you need a breather. Thank you so much. I really want to take a moment to thank Harry Payton, our chapter president, Nancie Marzulla, Arnie Lutzker, and Annabelle Collinson. I provided my contact information here, and I hope many of you will stay in contact and that when COVID is over, we can meet in person in Miami. Thank you.
That's great. Thank you very much, Amber. I'd like to sort of pick up, first of all, perhaps by endorsing and incorporating by reference everything that Amber said. And what we have found with our court is that generally a day before a hearing, the court clerk will communicate with us, the court's law clerk, and we will actually test out our technology to make sure that it's going to work, to make sure that everybody who's going to be involved has the opportunity to be able to tune in and to test things out to make sure that they're going to work. Well, I, like others, have perhaps 3 points to make, recognizing, as Nancie said, that we here in Washington, practicing in the Court of Federal Claims, a court with national jurisdiction, national subpoena power, has nevertheless concluded for many years that we don't need to bring every lawyer and every witness here to Washington for every hearing. Now, to that end, sometimes the judges in this court will pick up stakes and actually go out to where the witnesses are, where the property is, where the events occurred, and hold trial in a district court courtroom that has been borrowed. Obviously, like everyone else, our court has been shut down, and so the court has begun to adapt to that. We haven't had any trials yet, but we have continued to have hearings. Well, point number 1 is that all that stuff that we all learned in law school and that we prided ourselves over the years and decades on having learned about commanding the courtroom, about relating to the judge, about controlling the witnesses, about structuring a trial, about using breaks in the trial process to gather our thoughts and pull things together. That whole structure needs to be rethought because performing on a computer video screen using a platform, and incidentally, the Justice Department has prohibited their lawyers from using Zoom. And so we find ourselves using Skype at the moment and perhaps considering using other platforms. You really need to rethink and restart your analysis of how you're going to present cases, so that you are taking into account the fact that you do not have the majesty of the courtroom, you don't have the interaction among people in a single room, you don't have a chance to kind of pull opposing counsel to the side or to chat with your witness out in the hallway. So you have a very different set of dynamics, and of course, you are robbed of all of the cues that come from body language, from seeing people whispering, from knowing who's in the audience, from seeing who comes in or goes out of the courtroom. So lesson number one, I think, is we are all in a brave new world of litigation, and we are all trying to determine what skills will work in this brave new virtual world. Point two is that in preparing for hearings, I think you need to recognize what we have discovered is that your presentation is narrowed down. You're in a little tunnel. You're crawling through a pipeline here. No longer do you have the entirety of the courtroom to sort of use as the stage for your presentation. You're a little postage stamp on the judge's screen, and there are other little postage stamps there who you really can't communicate directly with. That is, you can't lean over and whisper in co-counsel's ear or have that kind of conversation with your client. So what we have discovered is, first of all, and you've heard it from everyone else, and I guess this is no new lesson, preparation. I think you need to plan out your oral arguments much more carefully. I think you need to do a better job with your written presentations in motions, be they summary judgment or discovery or whatever, because you're going to have a limited ability to converse with the judge, to clarify things, and as anyone who has dealt with Zoom realizes, there are these awkward times, whether they be a function of the digital timing problems that arise in using any kind of computer software, or whether they are just sort of miscues. But the judge will ask you a question perhaps, and you will give an answer, kind of thinking this is going to start a conversation with the judge. Well, it doesn't, or maybe he cuts you off not exactly realizing you're not quite finished. So in terms of hearings, it has been our discovery over the last several months that your argument and your presentation needs to be strong, clean, to the point, and that any of the flourishes, any of the kind of additions, the frosting on the cake that all of us are fond of using in the courtroom simply isn't available to you on a virtual platform. And so you've got to recognize that you have two things to work with. You've got your face and you've got your words, and basically that's it. It's a much more limited palette, so you need to paint in black and white. Third, to look forward to dealing with witnesses. As Nancie indicated, we have dealt with witnesses from across the country by video conference. We've dealt in trials with witnesses from territories of the United States, from Puerto Rico, Virgin Islands, Guam, and examined those witnesses using video conferencing. Well, setting aside all of the glitches that we all know about, including screens freezing and people not being able to hear and people dropping off and one thing and another, there's a whole different set of issues when you're dealing with that kind of witness. And our suggestion is that counsel deal with this in advance in some kind of a pretrial order, because you have no way of controlling the circumstances under which that witness is operating. We once had a case in which the Justice Department presented a distant witness by video conference, but we discovered that they had actually stationed a Justice Department lawyer off camera to assist the witness in giving his or her testimony. Well, obviously, you have no opportunity to see what kinds of signals, intentional or unintentional, are being given, be it by something as blatant as that, or perhaps by a friend, a spouse, another witness in the same matter. So the pretrial order needs to deal with the circumstances under which a witness is going to testify. The witness shouldn't have available the kinds of digital devices Amber just talked about, so that the witness cannot be provided with encouragement or answers to questions via a cell phone or a tablet. I guess the final point I'd make about witnesses is similar to the principle with respect to hearings, and that is, once again, because you have a very limited tunnel within which to communicate with that witness, within which to have that witness communicate with you, it's vitally important that you kind of shear off all of the unnecessary and excess kinds of things that you might want to do in the courtroom. You don't have the benefits of timing, not necessarily even the benefits of being able to follow up with the witness. I think witness control becomes a key issue when you're examining a witness over the internet, over a video conference platform. And that means that your questions have got to be strong, straight, to the point, the kind of thing that is going to elicit the sort of evidence that you need. And you need to hold that witness to his or her testimony, whether it be by using a deposition transcript to make sure they don't stray from what they've testified to before, and using documents and using the kind of the circumstances to keep that witness on point. And finally, as to that witness, we've done a lot of talking about documents, and there are electronic ways of doing it. Historically, what we have done, be it a live trial or be it a virtual trial, is to provide the witness with a notebook of documents, an individual witness notebook that is just the documents we're going to ask that witness about. Our trials often involve hundreds, even thousands of documents. So it doesn't work to provide the witness with an entire compendium of documents, but rather just the exhibits we're going to examine that witness about. So if you can provide that notebook to opposing counsel and to the witness so that you can work your way through it, obviously you give up some surprise, but in return, I think you make it a much smoother examination. Those are the tentative thoughts that we have as we launch into, hopefully, reopening the courts for virtual trials. And maybe we'll come back and give you an update as we get more experience in that regard. I'd like to now turn it over to Sam Rabin, who I think might have a slightly different perspective on all this.
Thank you, Roger, and thank you, Amber. You both are great contributors. And as Roger said, I do have a different perspective. I am a criminal defense practitioner and practice in both state and federal courts in Florida and throughout the country in federal courts. And I can tell you that while the civil lawyers and practitioners in administrative hearings are embracing technology, for the most part, criminal defense lawyers are trying to hold it off as much as possible. there are constitutional issues that are implicated in criminal representation of clients. Fifth Amendment right for them to remain silent, Sixth Amendment right to effective representation, and due process rights under the 14th Amendment. Florida is one of the few states that has depositions in state criminal cases. I have tried to do depositions in criminal cases where I've tried to do it with less important witnesses because I wouldn't want to do it with a critical witness. And even with the less important witnesses, and I'll give you one example. I have an arson case in Key West. It was convenient for me, it being in Miami, to try and take the less important witnesses, less critical witnesses, depositions via Zoom. And they were police officers that just came on the scene after the fire and after all of the critical evidence had been collected. And even with those witnesses, I found them looking at reports and trying to disguise the fact that they were looking at reports. I found them looking over at the prosecutor who was off camera in what I believe to be attempts to get coaching as to how to answer questions. And I found it very disconcerting. And I found that the process did not enable me to be effective because I wasn't there to see what was going on. I wasn't there to see if there indeed was coaching going on. And I wasn't there to see exactly what the witness was doing. And I asked him, it looks like you're looking at something. You know, when it was apparent to me, he was reading his report. And I said, you can refresh your memory from your report. There's no problem with that, but you need to let me know that. And it was clear to me throughout the depo that he was refreshing his memory from his report or reading it without telling me. So those are some of the problems with depositions. In the context of trials, neither state court judges nor federal court judges would endeavor, at least at this point, to try and do any kind of a criminal trial via Zoom or any other type of media. However, there are some federal judges that are trying to do sentencings where the client or defendant has already pled guilty and they want to go forward with the sentencings. And the way that they envision these working, I have one actually scheduled next week, which I tried to put off, and the federal judge refused to allow me to put it off. So the way she envisions it working is the defendant who is in custody, I have a choice of not going to court, him appearing by Zoom, me appearing by Zoom, the judge appearing by Zoom, and the prosecutor appearing by Zoom. So nobody is together. And I have significant concerns about that because, first of all, Fifth Amendment concerns. I'm afraid that I'm not with my client. He may want to say something that may create a problem for him. And I feel that as an effective advocate for him, I can't be effective if I'm in one place, he's in the other. And how do I confer with him? How do I talk to him off camera and tell him, listen, you can't go there. You can't say that to the judge. It's wrong. It's contrary to something we've written. You need to be more apologetic. So there's significant problems when you're not with your client. So that's problem one. Problem two is, I don't know how you can effectively advocate to a judge who's kind of on camera, but you're not in the courtroom. You don't have, as somebody's already said, the majesty of the courtroom, the solemnity of the environment. And in a lot of my sentences, I want to pack the courtroom with witnesses, so the judge can see that this person has a body of support. You can't do that in the era of COVID. I have this case. The judge basically limited the courtroom to 10 people because I said I didn't want to do it via Zoom. So the 10 people are the judge and the court security officer. That's 2. Me and my client is 4. The prosecutor and his agent are 6. That leaves a total of 4 spaces for spectators, witnesses, observers. Anybody else has to appear by Zoom. So I find it to be ineffective. I find it to be unfair to somebody whose liberty is on the line. And that is why, as a general rule, I try and avoid Zoom proceedings. And I think that it involves constitutional issues that, quite frankly, Zoom does not permit you to get around. I'll tell you one last story about a Zoom hearing I did have. It was not in a criminal context. It was in a quasi-criminal context. I represented a petitioner in a domestic violence action. And we were all supposed to go to court because the judge did not trust the respondent, who's a law student. And she had been very disruptive in court proceedings. So the judge didn't want to have a Zoom proceeding involving this case. So she declared it an emergency, and we were all supposed to go to court. The respondent, law student, got a note from a doctor saying that she was immunodeficient and therefore couldn't go to court. So a Zoom hearing was thrust on us, even though the judge didn't want it to be a Zoom hearing. All of these hearings that people are talking about contemplate everybody being cooperative, everybody wanting to have the hearing, everybody wanting to achieve the end result of a judge making a ruling. But where you have a recalcitrant party, as this respondent was, it all falls apart. So we have a Zoom hearing. The first thing that happens is she gets online, and you can see where it says audio connecting, and then immediately her audio would disconnect. And so she was saying, she was texting in the chat box, I can't hear, I can't talk, there's something wrong with my audio. Okay, so the judge said to her, why don't you call in on your phone? We'll use the phone for the audio, and we can use the Zoom for the video. What does she say? I don't have a phone. So now you've got, we're here for a Zoom hearing, and she's claiming she can't hear. So we spent 20 minutes, and she finally got her Zoom audio working. Then we start the hearing, and she's saying, well, I can't pull up, she was going to testify, and she's saying, I can't pull up my exhibits. So the judge said, well, you know, you're responsible for your own exhibits. And she said, well, I can't pull them up. And she was talking over the witnesses that were testifying. And essentially, it became a very difficult hearing to have from the point of view of a litigant, and a very difficult hearing for the point of view of the judge trying to control it. So in summation of all of the points I've just made, criminal defense lawyers and the criminal courts, I think, are going to be the last to embrace this technology, the last to have Zoom hearings, and I do not foresee any kind of Zoom trials, although in Miami they are going to do some testing on Zoom trials in the civil arena, but there's no talk of doing that in the criminal arena. But I will just tell you that I think that the constitutional issues that I brought up at the beginning, Fifth Amendment, right to remain silent, Sixth Amendment, right to effective representation, due process rights in a number of amendments, including the 14th, preclude us criminal defense practitioners from embracing this technology, and we do so on a very limited basis. I want to thank you all for inviting me and for allowing me to speak to this group. And I look forward to meeting many of you in person in the DC chapter, the Miami chapter. Right now we're Zooming as well when we meet, but thank you all.
Well, thank you, and thank the three of you for just a superb panel discussion. I'd like now to see if Bert, are you still with us? I know you had a scheduling issue that arose.
I tried to put it off. We'll see with what success. If you could do the multiple pictures, that'll permit me to share my screen.
Yes, I think I have done the multiple pictures.
You should be able to share your screen.
That opens up some of the functions at the bottom that are obscured now.
Share screen is open for you.
I can't, as I say, because of the way the screen is displayed, the functional tabs are not available. If we could move all these pictures to the right and get all the multiple pictures going, the function icons pop up again.
That should be on your end. If you can press at the top right corner of your screen where it currently says gallery view. If you press it, and then it'll say speaker view. And then that should give you some options, but share screen should be at the bottom of your screen. You are calling in though,
Okay.
so I don't know if that changes depending on your device, but it should be at the bottom of your screen.
Well, hold on. Let me see if I can.
Yes, we
There
see
we
it.
go.
I see it. I see your information.
Hold on.
Yeah.
I may have other
No, we
things
can.
to.
Yeah, we can see your presentation.
Okay, hold on. Let me get it up again.
And thank you, Larry, for accommodating the schedule change. Thank you.
If you press the back, yeah, there you go.
Well, thank you all for letting me participate here for Fortney Scott. We were asked to try to bring you up to date on how COVID influences the kind of nuts and bolts of opening your office. And the one thing that has struck me from the beginning is that we are asked to respond and address a number of issues that are completely foreign to our experience. I mean, what do I know about ingress and egress and lobbies and elevators and bathrooms and gridding and masks for that matter? So we're trying to think of these things in light of the kinds of issues that face you when you consider reopening the office. This first slide just gives you a kind of run through of if you were a cub reporter of, you know, who, what, when, where, what you have to do. And the main one is the first one, is you really have to, as Roger and the others were talking about, reimagining your argument. You really have to reimagine your workplace. You know, what needs to be done in an office, what needs to be done elsewhere. If it's going to be in the office, do you have to reconfigure? Do you want to stagger people? Do you want to grid people? And we'll try to talk about those. For those of you that want the last word, as it were, the CDC has recommendations for the office. They are mainly health-related and don't really address some of the issues that are going to confront you on a day-to-day basis. But the last three, which we'll be talking about in a minute, are the ones that you have to really focus on. The engineering controls, are you working with your landlord for the most part, and then working within your own office to see about gridding and screening, encapsulating groups of people, reconfiguring who works with whom. The administrative controls are your policies, and of course, teaching your workers to do what they need to do in order to work effectively and safely. The first issue is the one where you have the most experience and can be most effective, and that is mainly thinking about what needs to be done in the office. You've all been working remotely, you know what's been most successful, and you know what you could probably use some help with elsewhere. For example, if you're staffing a big litigation, you may want the attorneys and the paralegals to finally get together. But then you think about who and how to interact. Do they need secretarial help? How is that going to work? Do you have, if your office is large enough, can you encapsulate? And the reason you encapsulate is that if anybody gets ill, you know that's just that group of 4 or 5 people that have to be isolated, that have to go visit to get medical care. It's a whole rethinking of how you use the office as a center for work. So the most important one from my point of view is thinking about, in light of the fact that you've been working over the phone, over the internet, through Zoom or whatever, WebEx, Microsoft Works, what needs to be done in the office. And once you've made that decision, to figure out who gets staffed and how it's staffed. And these are the kinds of things you have to work with the remote people and how that works, that intersection works. It is a mindset that most lawyers are not experienced with. It has been a real mind-blowing experience in every respect to try to think myself through what you have to do. And you really do have to work with your landlord, because the flashpoints, the kind of narrowness, the constriction points are the lobbies and the elevators and the bathrooms, over which you have no control. So you really have to work with perhaps staggered entries. If you're in a very tall building, you're going to have way more trouble than those of us in DC who are, you know, capped at 13. But if you're in a 50-story building in Miami, getting everybody in is going to take a great deal of thinking about how you stagger the staff. Do you have shifts? There are a whole number of things of that kind to think about once you make the decision. So you have to have criteria. And here we have some law. The EEOC has gone back and forth 3 or 4 times. The main thing to remember when you start to bring people back, have neutral principles for how you do so. Clearly, if it's just the people working on a case, that's kind of self-defining. But if you're going to have the office, quote, open, you should have neutral principles that meet your business necessities. The EEOC first thought that they could say what the CDC said, don't let vulnerable people back in the office. Well, that doesn't work. The EEOC has recognized that that is discriminatory under the ADA and the ADEA. Mind you, you can respond affirmatively to someone who says, I don't want to come back. That's a voluntary consideration, not an accommodation, folks. But you cannot impose that limitation on workers like me in the vulnerable age category who want to come back to work. So think about the neutral principles that you will be able to apply when you're staffing your office. And then, of course, there are other things. We are human. We recognize schools are closed, camps are closed, people have children at home, childcare is closed. There's nobody, not even in those few states that are nearing phase 3, which have opened childcare yet. So think about, again, considerations that you can make to keep people working remotely insofar as that makes sense for getting the work done. If there are people with sick spouses, if there are people with young children, those are considerations that you are permitted to make and can make insofar as it meets your business requirements. But with respect to overall choices of who's coming, make sure you have neutral principles. It's very, very important.
Bert, do you have a final point?
Mm-hmm.
Because we need to get to 2 other speakers before we have to wrap up here. Yeah.
Well, all right. Let me just tell you one thing. If you go on FortneyScott.com, we have something like 10 of these PowerPoints, all dealing with COVID. This particular PowerPoint is extracted from the one we presented, I think, on the 1st of June. The main point is to make sure that you reimagine your office and learn about how people can come in. And this one here, what are you going to do to make your workers safe when they do come back? Will they self-certify about their temperature? Are you going to screen? What kind of screening you're going to use? Protocols for leaving, going to lunch is now a big deal. Going to the restroom is now a big deal. Have protocols. Think about how you're going to make that all work. And I'll leave it to the others to fill in the blanks, and thank you for your time.
Well, thank you, Bert. You've obviously got a lot of good information for us all, as does everyone on this program. It's been thus far a fabulous program. Larry, are you ready to go? You're muted. Can you unmute yourself?
I am unmuted.
Depart.
I am going to use a screen share. I want to encourage everyone to stick around for Nick Kosar, who will follow me, I believe.
Yes.
So I will be...
you can move quickly through your remarks. We'll get to Nick.
I will try to move through them with supersonic speed. Can everyone see my slides?
Yes.
Yes.
Okay, so I'm Larry Ebner from Capital Appellate Advocacy in Washington, D.C. I'm an independent appellate advocate with a nationwide appellate practice that focuses on cases involving the federal government and federal issues. And I'm going to speak briefly about the virtual world of appellate advocacy now that we've heard about pretrial proceedings and trial proceedings, both on the civil end and the criminal end. And here are my 3 key points. The federal courts are still operating, but many courthouses are closed to litigants and the public. Electronic filing continues to be predominant. and paper filings are mostly discouraged, at least for now. And almost all appellate arguments, oral arguments are virtual. They're mostly telephonic, but some are being done by video. Let's turn to the Supreme Court. As of March 19th, the Supreme Court extended from 90 days to 150 days the deadline for filing cert petitions. So if you're involved in that type of situation, you now have 5 months rather than 3 months to file a cert petition. And as I think you all realize, the justices continued to meet this spring. They met electronically. I don't know whether that means by telephone or video. No one outside the court really seems to know, but they have continued to consider and dispose of cert petitions and also to decide cases. And in the last week or two, there's been a steady stream of cases that have been decided on the merits. In the Supreme Court, for the first time this spring, oral arguments were held telephonically and broadcast live rather than being available through an audio link the next day. And one change is that the Chief Justice called upon each justice in order of seniority to ask questions. I think each had 3 minutes per side, rather than interrupting each other's. And perhaps Justice Thomas took advantage of this by speaking and asking questions. As you all know, he hardly ever asks questions, but he's asked a lot of them this spring. And there's this notorious flush heard around the world. One of the justices, we don't know who, took a bathroom break apparently, while the oral argument was being held. So it's called the flush heard around the world. And as I said, the end of term opinions are being issued. Let me turn to the U.S. Courts of Appeals. This happens to be a photograph taken by Nick Hosar, the next speaker of the U.S. Court of Appeals for the Fourth Circuit in Richmond, but I have some comments about the federal courts of appeals in general. First of all, the specific pandemic-related procedures are varying among the different circuits. As a generality, the case docketing process and the kind of upfront procedures for getting an appeal going from the internal court's operational viewpoint has been slower because not too many people are physically present in the clerk's offices, and they're spread out, and that just naturally slows things down. Many of the circuits have extended the discretionary filing deadlines. They weren't able to extend, for example, the statutory deadline for filing a notice of appeal, which is 30 days in the federal courts unless the government's involved. But in terms of discretionary deadlines for filing briefs and so forth, they're being liberally granted. And as I said, all of the filings are electronic and all of the circuits, and most of the circuits have waived paper filing requirements. But coincidentally, just last night, the DC Circuit issued a notice stating that it has now reinstated paper filing requirements for filings that were deferred during the last couple of months. And the hearings are being held electronically, mostly by audio, but some by video. Let me just say something about us appellate lawyers. We love spending a lot of time by ourselves, sounds very lonely, I know, but by ourselves in front of our computers, researching and writing legal briefs. And that is actually a practice area for that reason that is tailor-made for working from home. At least this is something I have discovered during the past 3 months, and many of my appellate colleagues, I think, have a similar feeling. Most of what we need to do can be done online, from home. Many of us, unfortunately, are perfectionists, which means we're spending even more time editing and re-editing briefs before they get filed. But having said all that, we almost never pass up an opportunity for oral arguments, even if they are telephonic. Now, I've heard presentations in other organizations by federal appellate judges, and this is just a few bullet points of what they've been saying. They've been saying that overall virtual appellate oral arguments have been working pretty well, but they do not want virtual oral arguments to replace in-person hearings. They feel that Zoom hearings, where you can see the judges and the counsel, are better than telephonic hearings because with Zoom you have the advantage of visual clues that can be, the judges can see each other, they can see counsel and vice versa, but again, not as good as in-person hearings. But when you see these visual cues, you sometimes don't interrupt the judges or you anticipate when they're going to ask a question. Many of the circuits also are, the panels are asking questions in the order of seniority, and this has the advantage that the judges aren't interrupting each other. And as a result, some judges have said that the questioning may be more productive and go somewhat longer. Here's a key point that was also made early on about depositions. Appellate counsel should prepare for argument as usual. And I've heard several judges say that even if you're on a telephonic hearing, do not read your argument, even if it's just telephonically. The judges know when you're reading. It's highly discouraged, and it's just not the way appellate hearings are supposed to work. So what are we appellate lawyers saying about virtual hearings? Well, here are some tips. First of all, prepare as normal. That includes holding a moot court, even if it's an audio or video moot court. In fact, it's probably better to have an audio or video moot court so you can get used to the changes that are associated with audio or video rather than having an in-person moot court. Dress as normal for court. Don't come in shorts and a t-shirt, even if you're all alone and even if it's telephonic. Put on a sport coat or a dress. You're speaking to a court. This point has been emphasized by other speakers. Use the best audio or video device available, whether it's a computer or a telephone. It's better to stand, just like you do in a real appellate court, even if it's audio only. This is a real hearing, and most people think and speak better when they're standing, even though I happen to be sitting. Just imagine how good this talk would be if I were standing, but I'm sitting right now. Look for visual cues during video hearings. And slow down. Try not to talk over the judges, even though that might be difficult to do when you can't see the judges. So I know there's no time for questions or comments, but I understand these PowerPoints and the others will be circulated by Annabelle afterwards. This is a little bit of information about me. Call me if you have an appeal involving a federal question, either in federal court or state court. Here's my contact information, and thank you for your attention.
Well, thank you, Larry. That was a very cogent and interesting presentation. Nick, we have saved the best for last. You are next. Are you there?
Okay, thank you. Let me just see if I can get my screen share working.
Good.
Yes, can you hear me?
Yes.
Can you hear me?
Yeah, we can hear you.
Great, great. Just a moment. Let me get over to my desktop. And there we go. Well, I assume you can see my screen. Thank you for inviting me. I am honored to be, in the words of Roger Marzulla, the last postage stamp of the conference call. And so I am going to be keeping it brief. Just a quick snapshot from my background, since most of you don't know me. I spent little more than a dozen years at 2 AmLaw 100 firms in DC, doing marketing and business development campaigns across the United States, and also the opportunity to do the same thing in the EU through a Brussels office. Prior to that, I spent about the same amount of time in a lot of different roles in publishing, which unusually or maybe somewhat surprisingly has kind of played into what I do now, which is full-on digital marketing. I left Big Law about half a decade ago to go straight into this. So I was thinking, I never titled this, and I think you could call this presentation Marketing During COVID, but I think you could also say it's marketing at any time. And so what do I do every day? What do I do every week? I do a lot of different things. I get bored easily. I like working on a lot of different elements of digital marketing. But I wanted to distill this down into what I think is sort of the core of what is successful marketing. And by marketing and business development, I think of that as developing new clients, getting new matters, getting repeat matters, and in fact, getting referrals for the same thing. So I kind of boiled it down into what I think are the three main factors in successful client development. It's visibility, expertise, and trust. If you think about this, let's say there is an attorney who has a lot of expertise but no visibility. They're not going to get any work. If you combine two of these circles, you know, somebody who has a lot of visibility and expertise but no trust, that trust is really kind of the glue or the secret sauce that pulls all this together. And if you put all of those three together, that's where I've seen the marketing success starts to happen. So what I wanted to focus on was one aspect of this that I think is timeless, and it's always been a problem, not just with lawyers, it's with me, it's with everybody else, and it's really simple. People don't pay enough attention to other people. They don't listen to each other. A couple of weeks ago, I happened to follow some historians and archaeologists on my Twitter account, and this is a cuneiform tablet from 4,000 years ago from ancient Babylon. And this is actually a piece of business communication. It is from, I guess you could say, one merchant or businessman to another. And the opening of it starts with what we would now say from one person to the other, as per my previous email. And among the things that this person is saying 4,000 years ago is, good behavior it is that I write to you again and again, and you pay no attention to me. And that's what I want to encourage all of you. And there's techniques to do this. One of the things I thought about this when I saw this cuneiform tablet, I thought of all of those general counsel, corporate counsel, in-house counsel surveys that kind of roll through time. And on the one hand, when general counsel will say, you know, lawyers don't pay enough attention to me, they don't understand my business, that sort of thing. A colleague of mine over in the UK had a general counsel survey. It was about what in-house counsel are thinking in terms of during COVID. And this one general counsel said, I'm not hearing from my lawyers. Whereas the opposite is the people who understand me, understand my business, understand what I'm going through, those are the lawyers I keep for a long time, okay? So if we translate this back to that Venn diagram I had, and I'm saying this is a COVID-19 world, which is of course what this whole conference, this Zoom call is about, which is a digital world, is you've got the same three things: trust, visibility, and expertise. And what are we left with until the time that we can meet in person together is these are some of the factors and some of the things that I think can influence. Social media is where you can be visible. I put LinkedIn up here in particular because I think it is sort of the de facto business network. Of course, I know there are lawyers who make great use of even Facebook, depending on the markets and the work they're in. Expertise is often exhibited through the content, the blogs, the things that the content that lawyers produce. And then there's trust. And I think this gets in a digital world, gets into two basic things. Number one, the power of a referral. If I'm going to refer somebody to somebody else, no matter what the business, the industry is, I'm putting my own reputation at risk. And so the power of a referral is huge. I say also engagement. This means the interaction that all of us have with each other, okay? Those are signals to trust somebody. Notice I put INBLF with every one of these circles because I view all of you as members of this larger organization as kind of sitting on a lot of opportunity to do better at all of these, okay? So I want to give you a couple examples. And by the way, I think I counted almost 400 attorney profiles on the INBLF website. I suppose that it might be more than that. So if you put the power of all of you together, I think that could be quite useful. Now, this is an attorney I happened upon about 2 months ago. I don't know her. I'm just following her on LinkedIn. She may not, the way she markets her practice might not be everybody's cup of tea. But it's clear to me from following her that it works. She has her own way, her own style, which all of us should have. She publishes regularly on her blog, but more important, what I see is she's constantly interacting and paying attention to and commenting and liking other people's content. She's part of the community. She has over 3,000 followers, and I'll guarantee you, every week she is adding to her follower account because she's going back to that, the opposite of that cuneiform tablet in Babylon. I've got a couple other examples, and this is more in the INBLF fold. The one on the left, Nancie Marzulla shared about this very Zoom conference call a few days ago on her blog. I don't think she was inviting the entire world, but basically anybody who is of interest probably could get an invitation to this call. But what she was also doing was calling out at the very least some of the speakers on the call. What I imagine for you as members of INBLF is, what if at least half the population of INBLF was doing the same thing, supporting each other in their work? I think you're sitting on a very powerful platform. The right-hand side is from Larry Ebner's LinkedIn profile, and I just happened to happen on this. I know Larry was the guest of a podcaster, litigator Frank Ramos, a few weeks ago. And I remember talking to Larry, and he was saying, well, it was all about me, which is kind of what podcasts are about. But then he thought, you know, what I really want to do is I want to learn more about Frank. And he interviewed Frank, published an interview about Frank Ramos on his blog, shared it. And then lo and behold, David Crow, who is a lobbyist in the DC, sort of area, went ahead out of the blue and just shared Larry and actually promoted Larry, even though this blog post has nothing to do with him. So I think that kind of paying attention can really pay some dividends. So this is really what I've got for you. 2 recommendations. I'm sure most of you have a LinkedIn profile, but you can go back to it and what I would say, optimize it. You know, there are a lot of different sections about it that you can improve to make sure that your expertise is getting across. Make sure you're connected with all the people you can be connected with. You're sitting, with your membership in INBLF. I think you should be connecting with everybody in INBLF. Another thing is follow. You don't need to connect. You can follow interesting people. What happens between your connections and the people you follow? All the interactions that those people do on LinkedIn go into your newsfeed. So you can pay attention to people, like, comment, that kind of thing, and be a member of the community when you don't have the ability to, go to a cocktail reception or a luncheon or that kind of thing. So that's what I've got. I think if you want some more information about LinkedIn, Larry Ebner and I sort of interviewed each other to talk about LinkedIn. If you just go to Larry Ebner's LinkedIn page, I'm sure he would love to connect with everybody, but you could find this interview that is hosted on his website, and it goes into more detail about using LinkedIn. And that's really it. This is some of my details. You can find me on LinkedIn in different places. I'd be happy to connect with you, answer any questions, and I hope this was helpful. The bottom line for me is it really gets down to, I like old school thinking. I remember and worked when the internet didn't exist. And I don't believe everything is done, everything that's being done digitally can be used in sort of interpersonal human relations, which I think is kind of one of the core of successful business development. And that's what I've got, Nancie.
Well, thank you, Nick, and thank you, everyone. We've run over time, so I'm going to leave everyone. I hope that you are all wanting more, and that you're all going to be bombarding Harry and me with requests for more webinar. You want to hear more from these people, more in-depth discussions, more topics covered. So get back to us, give us your feedback, and we look forward to seeing you all again soon. Thank you.